all of these cases being the state of Texas versus Trevante Nichols. We, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years, signed by the jury foreperson. And in 24 CR 302, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years. And that is another verdict signed by the jury foreperson. You may be seated. The court has received and made a part of the record the decisions and verdicts in its punishment phase made by the jury. We have received a message on behalf of the jury that the jury has reached a verdict in this case or cases. There are 3 cases before the jury. Is this so now?
Yes, sir.
Is this verdict or verdicts unanimous ones? That is, one or ones that are agreed upon by all members of the jury?
Yes, Your Honor.
And do any of the jurors disagree with your foreperson's representations? No disagreement is indicated. The verdict or verdicts do indeed appear to be unanimous. I'm going to ask you to please pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict or verdicts. All right, the court has reviewed the verdict or verdicts. The defendant shall rise. In cause number 24 CR 300, the state of Texas versus Trevante Nichols, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment. This verdict signed on behalf of the jury by the jury foreperson. In cause number 24 CR 301, the state of Texas versus Trevante Nichols, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, signed by the foreperson of the jury. And in cause number 24 CR 302, in the state of Texas versus Trevante Nichols, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, and this verdict as well is signed by the jury foreperson. All 3 guilty verdicts in these cases are received, made a part of the record for all purposes. You may be seated. Ladies and gentlemen of the jury, at this time I have received and accepted your verdicts, finding the defendant guilty of the offenses of aggravated assault with a deadly weapon, second-degree felonies in each of these 3 indictments that were before you. That brings us to a close of phase 1 of the trial. We will now go to phase 2, the punishment phase of the trial. And let me repeat once again, you are still under all the instructions that have been given to you before. Let me see the lawyers real quickly up here, please. Thank you. We're going to huddle for just a moment, ladies and gentlemen. All right, ladies and gentlemen of the jury, what we're going to do is take a break, about 10-15 minutes, relax, stretch your legs, report back outside, and we will bring you in, and the parties have an opportunity to present any additional information they wish for you to consider for the purposes of punishment. All the evidence in the guilt or innocence phase is also something that the jury will consider by law, can consider by law in your deliberations, but the parties can supplement that information with other type of information so that you can make a most thorough decision in this case. So, and I understand that the presentation of both parties will be succinct. So we're going to try to get this presented. I'll have a set of jury instructions that are much shorter on the punishment phase. There are certain things that don't need to be duplicated. And then the lawyers, upon the presentation of the case and completion of evidence, I will read to you the jury charge. The lawyers will make their final arguments, and then you will go back to deliberate on a verdict or verdicts for the punishment phase. That's our plan. Okay, thank you. Everyone else remain seated while the jury exits first. Okay, anything to bring up by the parties right now?
Not from the state judge.
All right, we're in recess,
You wouldn't stick.
short recess. Thank you. Ready to proceed now with this second or punishment phase of the trial, as all parties are present and the jury is present as well. And the state may go forward.
Thank you, Your Honor. We will waive any opening statement for the purposes of punishment. We will, however, reoffer all of the evidence from the guilty innocence phase for the purposes of the punishment phase, Judge.
All right. They always do that, but by law, it's the jury is ordered to consider all the evidence presented, not only in the punishment phase, but also in the guilt or innocence phase. That by law is allowed for you to be considering in determining what is the appropriate punishment for this particular case.
State calls, I'm sorry, Judge.
Go ahead.
State calls Troy Robbins.
Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Please have a seat, sir. Thank you. Hold on for just one moment. The charges. Stand by, ladies and gentlemen. Having an electronic problem. The witness camera has gone dark. The lady that knows how to fix this is on her way. There she comes. Okay. Yeah, I the witness.
Yeah, no, the witness is on, but I see you when I'm looking back. I love that camera.
In what capacity?
I'm the best.
And do you have any law enforcement background?
Yes, I have 20 years at Fort Arthur PD, retired, and then some time at the Jefferson County Sheriff's Office before that.
And do you have any specialized training as it relates to fingerprinting?
Yes, I do.
And ordinarily, if you were going to prove up prior judgments or prior convictions, how, if at all, does that training in fingerprinting come in handy?
What we'll do is we'll take a fingerprint from a defendant and compare it to a print on the judgment to determine if it's the same person.
And a fingerprint is one way to authenticate or link a judgment to a defendant. There is another way, and that's through the identifying information contained in the judgment. Say, for instance, if a fingerprint is bad or not of good quality or missing altogether, right?
Correct. Sometimes the fingerprints can be pixelated, where we can't really compare them to the print we've taken. So in that case, we would use name, date of birth, SID number, which is a state identification number, other identifiers that you may have come up in the past to compare to link a person to judgment.
So fingerprints are one way to link a person to a judgment. Personal identifying information is another way to link a person to a judgment. And lastly, what about if a defendant just simply stipulates or agrees that, yes, that's me in this judgment. These documents are true and correct. Is that a third way?
That's correct.
Your Honor, may I approach this witness?
You may.
I'm showing you what I have previously marked states the exhibit number 87. Is it your understanding that the defendant with the counsel of his defense attorney has stipulated to the authenticity of that document?
Yes, it is.
Your Honor, at this time, State Officer states exhibit number 87. I'll re-tender it to defense counsel, but during the break, I believe, I know that he inspected it and stipulated to its admission into evidence. No objection, Judge.
May I look at that, please?
Yes, sir.
Thank you. Thank you.
State is state's exhibit number 87 admitted to evidence.
Is admitted.
Thank you. Mr. Robinson, for purposes of the record, I'm handing you state's exhibit number 87. What is that document or packet of documents? What is that?
So these are judgments, adjudicating guilt and cause number F20-34725-0, the state of Texas versus Trevante Nichols.
And a judgment for what type of an offense?
This offense here was for theft of a firearm.
What level offense is that?
State jail felony.
Okay. Now, how do those documents indicate how that case initially was disposed of?
Yeah, so initially, State's Exhibit 87, it was there was an order of deferred adjudication.
And so in other words, this defendant was placed on probation for that offense of theft of a firearm.
That's correct.
When was that? What would that date be when he was placed on probation?
The date of probation was 12/16/2021.
So in 2021, he was placed on probation for the felony offense of theft of a firearm. And it's, yes, sir.
That's correct.
And at some point, do those documents indicate whether or not he at least was alleged to have violated the terms of his probation?
Yeah.
And what do they indicate?
So in the documents on December 25/2022, Trevante Nichols committed offense of aggravated assault, exhibited a deadly weapon, and pled truth.
Okay. So 2021 placed on felony probation for theft of a firearm. 2022, he is accused of committing an aggravated assault.
That's correct.
Essentially the same type of offense that he is on or has been convicted of in this courtroom.
That's correct.
What, if anything, how was it, did he plead? Was there a plea? Let me choose my words correctly.
Yeah, so in a plea, it is stated that the state will not prosecute the December 25th, 2022 aggravated assault alleged in the MTRP in this case unless it is later received in its office. And the result of that was a true account of aggravated assault, and he was revoked on the theft of the firearm date 3/22 of 2023.
Let me unpack that, because you said a lot there. So as it relates to the allegation while he was on probation that he committed a new offense of aggravated assault, do the documents reflect that he pled true to that allegation?
Yes, they do.
Now, in the context of a probation case and pleading true to an allegation in a probation case, it's not like in your experience, it's not like you plead guilty or not guilty in a probation revocation case, right? It's either true or not true, right?
That's correct.
But a plea of true is essentially a plea of guilty. Is that fair to say?
That's correct.
All right. So in other words, if he pled true to that new allegation in 2022 of the commission of the new aggravated assault, it's essentially admitting his guilt to the aggravated assault. Is that fair to say?
That's correct.
All right.
Hold on, I thought it was a theft of firearm.
He was on probation for a theft of firearm, but the new allegation was aggravated assault, for which I believe the documents indicate a plea of truth.
Correct.
Okay. And is it your reading of those documents that as part of a plea agreement, the aggravated assault case was not prosecuted?
That is correct.
And as part of that plea agreement, was his probation for the theft of firearm revoked?
That's correct.
And once it was revoked, was he sent to state jail prison?
Yes, he received 14 months in state jail, Texas Department of Criminal Justice.
Okay. Take that exhibit. I think that's all the questions I have for you. I will pass the witness.
See, briefly, Mr. Investigator Robinson. Now, you stated that with his plea of true, he pled true, and it was agreed that the aggravated assault allegation would not be prosecuted unless received by the office or the district attorney's office. Is that
That's
correct?
correct.
Was there any time that case or allegation be accepted or received by the district attorney's office, to your knowledge?
I do not know.
So, but we do know that he was never charged or prosecuted for aggravated assault.
That's correct.
Okay. That's the witness.
Just to be clear, Investigator Robinson, whether or not case came over or he was formally charged with that offense or prosecuted by the district attorney's office, by virtue of his plea of true in a courtroom under oath, he essentially admitted to committing that offense of aggravated assault, correct?
That's correct.
That's what it was.
Anything else?
No,
Is this man excused?
Yes, Your Honor.
You are excused, sir. Thank you. Next, please.
Your Honor, at this time, the state of Texas rests.
The state rests. What says defense?
Yes, Richard.
All right. I'm going to ask you one more time, and this shouldn't take but 10 minutes, ladies and gentlemen. I'm going to ask you to exit, relax, stretch your legs. We are formalizing the jury instructions for this punishment phase, and or they're warm. I'm going, each the parties get a chance to review it first, and I think this can be done, and we'll get ready to move forward on final arguments here in just 10 minutes. So please exit, relax, stretch your legs, and report back outside then. Thank you. And here the lawyers come up and everybody gets one of these. Thank you. And the record shall show that the jury is exited, the parties are present. And let's go over this to make sure you have the right documents in the right order. And first page, members of the jury, it's an introduction page. Then second degree felony punishment definition, good time credit and parole. Defendant's election not to testify. General instructions. Then two verdicts, guilty. I'm sorry, guilty, we're running. Two verdict options for each number in 300 years, and that would be no less than 2 nor more than 20. And the second option, years, no less than 2 nor more than 20. A further assessing a fine not more than $10,000. 301, same option, two options. Years up to 20 years on the second, plus a fine not to exceed $10,000. And the third option, the third case, 302, has the same two options for the jury to consider, either flat time of years only, no less than 2 nor more than 20. And the second option, as all three options are the same, years, and further a fine no more than $10,000 can be assessed. Any objections? Y'all can see? We'll take a look at them and we'll start in about 5 minutes, okay? Thank you. We're in sharp recess. Is there anything else to bring up and bring forth before the jury in this case from the state of Texas?
No, Your Honor.
Or the defense?
No, Your Honor.
Ladies and gentlemen of the jury, the parties have rested their cases for this punishment phase of the trial. And again, you will be considering not only the evidence presented in the punishment phase, but also all the evidence presented in the guilt or innocence phases before you. I am going to read to you the court's charge here, which contains the law applicable to this case for the punishment phase of your jury deliberations. And in continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you. Again, these instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. And again, I know you will. Please listen carefully as I read this charge to you. As before, it will be left with you to refer to as necessary during your deliberations. Members of the jury, you have found the defendant guilty of the offenses of aggravated assault with a deadly weapon in cause numbers 24 CR 300, 24 CR 301, and 24 CR 302. It now becomes your responsibility to assess the proper punishment for each case. These offenses under our law are second-degree felonies. Second-degree felony punishment. Our law provides that an individual adjudged guilty of a second-degree felony shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice, I will refer to that as prison, for any term of not more than 20 years or less than 2 years. In addition to imprisonment, an individual adjudged guilty of a felony of the second degree may be punished by a fine not to exceed $10,000. Good time credit and parole. Under the law applicable in these cases, the defendant, if sentenced to a term of imprisonment, may earn time off the period of incarceration imposed through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignment, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. It is also possible that the length of time for which the defendant will be imprisoned might be reduced by the award of parole. Under the law applicable in these cases, If the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed or 30 years, whichever is less, without consideration of any good conduct time he may earn. And this is read directly from the law, but in this case, the actual time served, again, would be equal to 1/2 of the sentence imposed, or in this case, he can receive no more than 20 years, and these sentences will run concurrently. So when we say 30 years, that would apply for someone who was sentenced for a period of time of 30 years or more. And in this case, he is sentenced to no more than 20 years for each case, but these sentences shall run concurrently, as you are aware. If the defendant is sentenced to a term of less than 4 years, he must serve at least 2 years before he is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to this defendant if he's sentenced to a term of imprisonment, because the application of these laws will depend upon decisions made by prison and parole authorities. Now, you may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant, because you don't have any power over that. That's for other authorities to determine. And you are not to consider the manner in which the parole law may be applied to this particular defendant. Defendant's election not to testify. Our law provides that a defendant may testify in his own behalf if he elects to do so. And this is a right given to a defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. General instructions. The attached verdict forms are supplied for your use. When you have reached your verdict or verdicts, your foreperson should fill in the appropriate form or forms and sign their name as foreperson. In arriving at your verdict or verdicts, it is not proper to fix the punishment you assess by any system of averaging. Your verdict or verdicts must be determined only by a full, fair, and free exercise of the opinions of each juror based upon the evidence presented. Your verdict or verdicts must be unanimous. Your failure to follow the law contained in this charge could result in a mistrial being declared, and your deliberate violation of these instructions could result in your being held in contempt of court. We have 3 sets of verdict forms. One, there's 2 parts for each case. In 24 CR 300, we, the jury, assess the defendant's punishment at confinement in, I'll call this prison, the institutional division of the Texas Department of Criminal Justice, prison for a term of blank years, no less than 2 nor more than 20, a place for the foreperson to sign. Your other option on this case and all the other cases, we, the jury, assess the defendant's punishment at confinement in prison for a term of blank years, no less than 2 nor more than 20. We further assess a fine of not to exceed $10,000. And again, only one verdict form for each case can be signed. Okay. In 24 CR 301, same instructions and verdict forms. We, the jury, assess the defendant's punishment at confinement in prison for a term of years, no less than 2 nor more than 20. And your second option, we, the jury, assess the defendant's punishment at confinement in prison for a term of years, no less than 2 nor more than 20. We further assess a fine not to exceed $10,000. Only one can be signed in each case by the foreperson. And in the third case, we, the jury, assess the defendant's punishment at confinement in prison for blank years, no less than 2 nor more than 20. The other option, we, the jury, assess the defendant's punishment at confinement in prison for blank years, no less than 2 nor more than 20. We further assess a fine of not to exceed $10,000 and a place for the foreperson to sign only one signature in each set of jury verdicts, which is no more than 3 verdicts can be signed. Okay. As before, the state of Texas may open and close final arguments. What says the state?
The state would waive its right to open and reserve its right to close.
Mr. Lewis, when you're ready, sir, thank you.
Really should.
And the law states that in final arguments, as in the guilt or innocence, lawyers have a reasonable amount of time to make their final arguments for the punishment phase. There's no definition of that. So, but these lawyers know the rules, and they're succinct. They're not going to waste your time. Go ahead.
Thank you, Judge. Good afternoon, everybody. Of course, this is the last time you'll hear from me as far as this case is concerned. And so the first thing I want to definitely do is thank you for your service of coming up here, serving on this jury, and definitely from the time it took you to deliberate, we can see that you were definitely focused and attentive and paying attention to all the evidence that you had. And we do definitely appreciate that. Now, I will say that my client has maintained his innocence throughout this entire situation. So it's a situation where, although we may not agree what that verdict was, we definitely respect it. We definitely want you to know that. Okay. Now, going forward, I'm not going to just come up here and beg you to give him a minimum or anything like that. I understand that, there's a punishment going to be assessed in this situation. Judge has already gone over the range of punishment. But what I want to talk to you about with Mr. Nichols that is obvious from the testimony of Mr. Robinson, Investigator Robinson, there that, this is a young man who's made some mistakes. Definitely made some mistakes young in life. As of right now, he's 24 years old, sitting here today. So there was definitely mistakes that he made when he was younger. And what happens when you make those mistakes young, it makes it a lot harder to navigate out of situations later on in life. And that's one of the situations that Mr. Nichols finds himself in. So my main concern or ask of you as jurors in this matter is when you're considering that punishment, what that range is, what should be appropriate in this situation. I know we have to balance what happened out there that night, but we can't leave or not consider Mr. Nichols' life and his future. We still want him to be able to because at some point he will be released. But we want him to be in a situation where he can be productive and positive and move forward for not only but himself, but for his family. And also, of course, as a member productive citizen of our society that affects all of us. So that's what we really want. We want him to be able to still move forward and grow from this in some kind of way. Whatever that lesson may be, hopefully he's able to get it and sustain it and learn from it. Okay. And because at 24 years old, he's still very young. Still very young. And you see from the testimony of Investigator Robinson, the other issues he's had, he was even younger than that. So these are things that he's been tackling and dealing with for a long time. And a lot of times, like I said, just be able to make the right decisions when you already have things or hurdles against you, or you have to get over, it makes it tougher and tougher. And this situation is going to be another part of it. But he's going to have to deal with it. Even in the situation where he does maintain his innocence in this situation, he still has to deal with the repercussions of this situation. So I'm not going to ask for a particular amount of years or number. I'm going to trust you that you're going to the same consideration you gave to come up with your verdict. You'll do that again in assessing this punishment. And understand the goals of the punishment and hopefully what that final result can produce from that punishment. Thank you. Thanks, Judge.
State of Texas?
Here, please report. Yes, Mr. Lewis. Ladies and gentlemen of the jury, if you just give me a moment, I want to grab a couple of exhibits. want to begin by thanking you for your time and your, the effort that you put into your deliberations. And on behalf of Philip Bennett and on behalf of Messiah Bennett and Ayana, to thank you for your very, the right way in this case, based on the evidence. A couple of housekeeping things before I get, too far into my closing remarks. There's a mention, of parole in your jury charge. I would encourage you to pay some attention to that because at the end of the day, whatever your verdict is that you assess, whatever punishment that you hand down, there is a possibility that this defendant will be eligible for parole after serving at least half of whatever your sentence is that you hand out. There is that possibility. You can consider that. You can't, and there's some specific language in that jury charge. You can't say for certain that he'll get it. You can't because to say for certain would mean that you know that what the parole board would do and you don't know that. But you can, the law says you can consider that there would be a possibility that after half of the time that you assess, he'll be eligible for parole. Another thing to consider in that charge, it talks about a fine of up to $10,000. I would submit to you, don't spend any time on that fine whatsoever. If it were somehow to get paid, it won't go to the victims in the case. It goes to the state of Texas and who knows what they do with that. So I would submit to you, don't spend any time on the fine. And lastly, as far as in the way of housekeeping matters, in these instances where there are multiple indictments coming out of the same criminal transaction, inevitably the first note that comes out from the jury when you go back to deliberating punishment is, will these sentences run concurrently or at the same time? And I represent to you that they will. So in other words, whatever you assess in the way of a punishment, it's not like they will get stacked on top of each other. They'll run at the same time. So with those housekeeping matters out of the way, let's talk about a concept that we talked about during jury selection, and that is mitigating evidence, something that you can consider that would mitigate toward the low end of the punishment range versus aggravating evidence, something you can consider that would aggravate toward or depart upward toward the high end of the punishment range. I submit to you that the fact that he had previously been on felony probation for theft of a firearm and he didn't get the message and he could continue to commit his criminal ways, that's something that's aggravating that you should consider during your deliberations. I submit to you that even when he's on a felony probation, he goes out and commits the very same type of an offense that he's on trial for here today, an aggravated assault. A theft of a firearm, why are you stealing a firearm anyway? And you are committing aggravated assaults. Mr. Lewis talked about making mistakes and those mistakes making it hard to his words, navigate through life based on those mistakes. This is not criminal mischief. This is not some a DWI. These are serious offenses affecting the safety of and well-being of individuals, people. This defendant, for whatever reason, like I talked about in my closing argument in the guilty innocence phase, for whatever reason, there is something within this defendant that makes him violent, that makes him commit these types of offenses. And speaking of his violent propensity, the nature of his very offense is something you can consider. This very nature of this offense, the fact that we could be here on a very, very different type of a case. This could be a murder case. It didn't dawn on me because it wasn't mentioned in any of the office report or material in my file that a projectile actually struck the back of Ayana Oaks. It didn't dawn on me. And so I went back and I looked at State's Exhibit number 80, and there is a spent projectile in the back trunk of that vehicle. Here's a close-up, State's Exhibit number 81. There's a close-up of that projectile. By the grace of God, I guess maybe that the vehicle, the distance it had traveled, and whatever that projectile struck before entering that truck, slowed it down before it struck the back seat of Ayana Oaks. But think about that. And think about if it was, if you wouldn't have slowed down, and if it was just a little to the left or to the right, that poor baby inside could very well have been struck um, by that projectile. So again, his previous criminal history and the nature of his offense, I submit to you, it mitigates toward the high end of the punishment range. He's fortunate that all he's facing is 20 years. You know, I would submit to you that he is fortunate that all he is facing is 20 years. Look at these evidence markers marking all of those children. This is madness. And I was thinking about this morning. That very term came to mind. This is madness. And it reminds me of a line from a movie, and I don't often quote movies during my closing arguments, but there's a movie, you may have seen it, from 2006, 300. It's about the fictionalized battle between the Greeks and the Persians. And there's a line in that movie where the Persian messenger goes to that Spartan, the Greek king from Sparta, and he says, "This is madness." And that the response from the Spartan king is, "No, this is not madness. This is Sparta." And I submit to you that this is madness, and there are people in our community whose response would be, "This is Port Arthur," and it doesn't have to be there. We can change it. You can change it. It starts right here. You can end this madness. How? By sending a message with your verdict. You can send it with your verdict by saying, you know what? This is what we think of this madness. And these are the types of sentences we're going to hand down. And if you think for a second that your sentences don't matter, here's what my experience is. And you talk to anybody in law enforcement, these guys will tell you, your verdict, when you hand it down, before you get on that elevator and get to the parking lot, it will make its way back to the jailhouse. Those defendants will know, because it's just how that works. They'll know that this is what you think. This is what you think of this kind of violence. This is what you think of this madness. Not only will the people in the jail know, but the folks on social media would know. The same very circle of people that this defendant runs around with. The same people who were out there that day. He wasn't the only one shooting. Those same people will know that you and I will no longer stand for this madness. This is not Port Arthur. This is not Jefferson County. I am asking you. I like Mr. Lewis. I'm not going to ask for a specific number. I like him will trust that you'll do the right thing, and you'll get it right because you got it right with the guilt and innocence. That's all I have. Thank you.
All right, ladies and gentlemen of the jury, at this time, I am tendering the jury charge for the punishment phase from you on behalf of the jury, that the jury has reached a decision in the punishment phase of these three cases. Is that true, ma'am?
Yes, sir.
Is this verdict or verdicts unanimous decisions? That is, ones that are made of unanimously, all parties, all jurors present have agreed unanimous to these decisions.
Yes, sir.
Any of the jurors disagree with your four persons representations? No disagreement. It does appear to indeed be unanimous. As before, if you would pass the documents to the bed, if you may be seated, ma'am. The court will review for proper form and publish the verdict or verdicts. And the defendant shall rise. In cause number 24, CR 300, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years, signed by the jury foreperson. In cause number 24 CR 301, all of these cases being the state of Texas versus Trevante Nichols, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years, signed by the jury foreperson. And in 24 CR 302, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 14 years. And that is another verdict signed by the jury foreperson. You may be seated. The court has received and made a part of the record the decisions and verdicts in its punishment phase made by the jury. At this time, ladies and gentlemen, the jury, your duty as jurors is completed. At the beginning of the trial, I placed each of you under a number of instructions. And at this time, I am releasing you from those instructions previously given to you. One final instruction is added. Once you are discharged, you are released from your oath of secrecy. You are free to discuss the case and your deliberations with anyone. You are also free to refuse to discuss the case, and you have every right to maintain your silence unless otherwise ordered to do so by me. In a few minutes, the attorneys are going to be released after we do some formalities, and they always like to speak to jurors if you were willing to wait and talk to them. They like to get feedback. It helps them with their duties as lawyers, and they always find it rewarding to be able to speak with you to see what your feedback is and input for them to make them even better attorneys. But you're also free to go home or go about your business, but they will be discharged in a little bit. And again, you are free to discuss these matters with them as you choose or not. One final point. The flag that stands here not only stands for the United States of America with the state of Texas, but also it stands for the Constitution of the United States. We, the people, that's the way it begins. In order to form a more perfect union, establish justice. That's the very first part of how the Constitution begins. And jurors who come forth for jury service are right there in the first sentence of the Constitution. Your decisions determine what justice is. And a lot of people who are selected to come forward don't show up. They find other things they have to do. Sometimes they're good reasons, sometimes it's not. But in this county, we have a very great citizens for the most part who do show up for jury service. I want to thank you for your time and your attention. You're going to get a little stipend, but it's not enough financially to reward you for your important time. But whether it's serving in public office or serving to defend our country or serving to make the Constitution work, since a trial by jury is in the Bill of Rights. Without jurors, good citizens, we are unable for this country to work. And I want to thank you for doing your service and obligations as good citizens. I hope to have the honor to work with you in the future. Until then, may God continue to bless Jefferson County and her citizens, and you are excused. Thank you very much. Ellie has documents if you need it for work or school or other purposes. Thank you. And the lawyers will be out in about 5 minutes if you wish to talk to them. And Mr. Sharp, again, thank you for your citizenship and holding. You look awfully young, sir, for your age.
Thank you.
We were born a day apart. But he's older than me by 1 day. Yeah.
It matters. That's something. And it's you, Judge.
Hold on. We still have a formality.
Yes.
All right. At this time, is there any legal reason why formal judgment should not be assessed? Defense or state?
No, no.
And this court is going to refer to each of these three cases since the parties agreed for cause numbers 24 CR 300, 301, and 302 to be tried at the same time. Each of these were second-degree felonies of aggravated assault with a deadly weapon and occurred in during the same episode with three different victims or complainants alleged, one in each indictment. Trevante Nichols, as defendant, you came before this court and a jury, entered a plea of not guilty to each of these three offenses as set out in these indictments. The evidence was submitted. The jury was charged by the court after deliberating. The jury returned verdicts in each of these cases, finding you guilty of the second-degree felonies of aggravated assault with a deadly weapon. Thereafter, evidence was presented and the jury was charged for deliberations on punishment, and the jury assessed your punishment at confinement in the institutional division of the Texas Department of Criminal Justice, that is prison, for a term of 14 years for each case. Is there any legal reason why sentence should not now be finally and formally pronounced, state or defense?
No.
Finding nothing to bar pronouncement of sentence, it is the judgment of this court that you are indeed guilty in cause numbers 24 CR 300, 24 CR 301, and 24 CR 302. Each indictment charging you with the second-degree felony of aggravated assault with a deadly weapon. And you shall be punished in accordance with the jury's verdict of guilty in each of these cases. It is therefore the order of this court that you, Trevante Nichols, who has been adjudged guilty of the offenses, three offenses in these cases of the second-degree felonies of aggravated assault with a deadly weapon, and whose punishment has been assessed at 14 years imprisonment on each of these cases, shall be delivered by the sheriff of Jefferson County, Texas, to the director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 14 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. You are here now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of each of these sentences. These sentences, by law, shall run concurrently. Do you understand what has happened throughout this trial and today, sir?
Yeah.
Anything else to add by the defense
No, sir.
or the state?
No, sir.
And y'all have filled out the appeal
Yes.
formalities on behalf of the defendant?
Yes.
All right. Nothing further. These proceedings are concluded and this court is in recess.